A federal judge in Chicago has once again blocked the Trump administration's public charge rule from taking effect. This is U.S. District Judge Gary Feinerman in a November 2nd ruling. One of the reasons for blocking the rule nationwide is he said the public charge rule violates the Administrative Procedures Act. Now, that's a law that makes federal agencies accountable to the public by outlining a detailed process for enacting regulations. He said that didn't happen here. In fact, the Trump administration stretched the meaning of public charge beyond what the immigration law allows. Also discussed in front of the judge, but not decided, is whether or not this rule violates the Equal Protection Clause. Does it treat white immigrants differently than non-white applicants coming into the country? Not decided, but something that will proceed in the courts. Let's take stock of what we're talking about and then where we've been in the courts, because this has bounced around quite a bit. This is the inadmissibility on public charge grounds rule out of the Department of Homeland Security. The idea of the rule was to change the definition of public charge. Public charge is a rule that's existed for a long time, but it's applied to individuals that get cash assistance from the government. In this instance, the Trump administration wanted to broaden that definition to include individuals that get non-cash assistance, such as Medicaid, food assistance, or housing assistance. The purpose of the change would be to expand the federal government's ability to deny visas or permanent residency to legal immigrants. It also gives an awful lot of discretion to immigration officers and considers the use of public benefits a heavily weighed negative factor when someone wants to change status. There is a totality of the circumstances test that is used when someone wants to change status, whether they will be what is loosely considered a burden to the United States. And in this instance, the Trump administration wanted to say using Medicaid or housing assistance or food assistance would be a burden. Let's talk about where this rule has been. It has bounced around quite a bit from last October into the winter months into 2020. And it was back in January of 2020 that the U.S. Supreme Court said the rule could take effect in its new implementation date of February 24th, as had then been planned. In August, a federal judge in New York blocked the public charge rule from taking effect during the coronavirus pandemic. By September, however, the Second Circuit Court of Appeals reversed that hold and the rule took effect nationwide once again. So this ruling out of the judge in Chicago finally blocks that rule once again nationwide as of November 2nd. Now, it was that judge in New York, Judge Daniels, that spoke to the rule itself being a deterrent to people seeking testing and treatment during coronavirus, the chilling effect that it was having in a time of national emergency. In the meantime, the U.S. Citizenship and Immigration Service had issued a memo saying getting testing or treatment for coronavirus won't be a negatively weighed factor for someone should they choose to change status later. But Judge Daniels said that's not enough. Just the fact that the rule is out there alone is keeping people from getting medical services at a time of national emergency. In his opinion, he said the worsening of the COVID pandemic has created an urgency, and we no longer need to imagine the worst case scenario. We are experiencing it in real time. That concern was echoed by doctors and public health officials, and you can bet certainly weighed on the mind of our judge in Chicago that ruled on November 2nd. So what to expect next? An appeal, most likely. U.S. Citizenship and Immigration Service has already said they see this proceeding through the courts. So litigation will continue. There's also that litigation on those other issues, the equal protection issues, that will continue as well. It's an immigration fight just as much as it's a legal fight. This is a political battle, not just one that's working its way through the courts. It could end up back before the U.S. Supreme Court like it did in January. This time it would look a little different. We have a new Supreme Court justice than we did back in January, and she may have to recuse herself. She was one of the judges that heard a challenge to the public charge rule back in the middle of summer. She dissented. The balance of the court blocked the rule from taking effect. She thought it should go into effect. So should this rule come back before the U.S. Supreme Court, their newest justice, Amy Coney Barrett, may have to recuse herself. Should any of this happen, we will keep you posted and bring you updates on this channel. In the meantime, you could read the opinion coming out of Chicago on November 2nd. Also, if you need to talk to an attorney or have questions about your own status, your own use of public benefits, we link to the National Immigration Law Center and the National Immigration Legal Service Directory so you can find help in your area.